Hello, my treasured viewers. I am happy to be back once more with you on this channel. Do you know that the family and marriage laws of the land affect you? Yes, these laws are summed up in the Marriage Act, an act of Nigeria's National Assembly that regulates the relationship between couples in the contract of marriage. Are you aware that even as a child, the marriage laws of the land affect you? As a spinster, as a bachelor, who are already thinking of marriage or not thinking of it, the family and marriage laws of the land affect you, either directly or indirectly, once you are a member of a human family in the country. Of course, you are aware that as a married couple, as one of the parties in a marriage arrangement, that the marriage laws affect you. It is a law that no one can wriggle out of. No one can wriggle out of the effect of these laws. Once you are part of the human family in the country, the marriage laws of the land affect you. Which is why it has become paramount that we do not wait until it becomes too late. That we do not wait until we run into a marriage problem before we begin to learn about our rights or our duties under the Marriage Act. A warm good day to you all. My name is Ogochukwu Onoha, and the channel is HumanRightsHeralds. You are onto a half hour with the Human Rights Wizard. And as usual, it is my pleasure to help all of us understand the law, interpret the law using a layperson's language, so that we can all better understand the rights that we can demand from the law and the duties that the law demands of us, so that by so doing we can have a just and harmonious society. So before us to discuss today, therefore, is the marriage laws of the land. What is marriage? Now, a union of two people, usually of opposite genders or opposite sexes, a man and a woman, for the purpose of reproduction, in order to propagate and perpetuate the human population. That is what marriage is. In Nigeria, marriage can be contracted under two basic laws. These two basic laws give rise to two brands or two types of marriage in a Nigerian context. There is the statutory marriage celebrated under the Marriage Act of 1914. Now, this act is not indigenous. It was derived from the colonial masters. Many of the laws that are interpreted by our court system have English origin. They were copied from the English law. And apart from the statutory marriage, which is consummated under the Marriage Act, there is also the customary marriage, which is contracted under the customary law. In 1970, Nigeria adopted the Matrimonial Cause Act, 1970, another law derived from the English legal system. The purpose of the Matrimonial Cause Act is to dissolve a marriage contracted under the law. That is, to dissolve a statutory marriage. Let us take that again. When marriages cease or stop to bring joy, to bring harmony to the two parties involved, one or two of them may want to put an end to the union, much as is the case with any other form of a contract. When this happens, they may go to court. In the court, the Matrimonial Cause Act will be interpreted to find out what provisions it makes for the dissolution of a particular marriage. I need to point out at this point that the two marriages, or the two kinds of marriages I had already mentioned, are conducted under two kinds of laws. In Nigeria, for instance, the statutory marriage is legislated under the exclusive list. I need to explain these legal jargons using simple ways that you can understand. When I say legislative list, I mean that statutory marriage according to English law in Nigeria, that laws relating to such a marriage are listed under the exclusive list. When we say exclusive list, we mean that only the federal government of Nigeria has the right under our constitution to make laws concerning such a marriage. And in this case, the federal government means Nigeria's National Assembly. So, laws related to a statutory marriage are made by the National Assembly. Then there is the other marriage, contracted in the customary marriage. Laws related to the customary marriage are listed under the residual list. The residual list is a list of laws or a list of areas where only a state in Nigeria can make a law. And when I say a state, I mean the House of Assembly of a state, of each state, can make laws on issues related to customary marriage. Now, the two kinds of marriages, statutory and customary, are related in some areas, but they are also not related in other areas. What do I mean by those areas where they are not related? I'll give you an example. Polygamy is a feature of a customary marriage. It's a marriage system that allows the man to marry two wives or more. But the woman is not allowed to marry more than one man under the same customary law. The statutory marriage law, for instance, however, provides what is called monogamy. In other words, a man can only marry one woman under the statutory law, and a woman can only marry one man under a statutory law. In other words, it's a marriage between one man only and one woman only, and it is called monogamy. Marriage is like any other kind of contract. Please watch our video on tenancy and the law of contract, where we discuss terms of contract. So terms of contract, like offer, consideration, and acceptance, and the privity of contract, also feature. They are all a part. They are all a part of the marriage contract. Now, a customary marriage has betrothal as a feature. Why? a statutory marriage has engagement as its own feature. So you can see areas where they differ. Let's talk about betrothal. In a customary law, a baby can be betrothed to marry a man who is already mature, an adult man. What happens is that in different cultures in Africa, the man who intends to marry the baby girl, or who intends that baby to be married by his own son, who is still a boy, goes to the father of the newborn baby girl and discloses his intention. In some cultures, in parts of Igbo land, for instance, the man will put some money, coins, in a calabash, put some water in it, and present it to the parents of the baby girl. This symbolizes his intention to have the little girl married to his son when they both grow up. And as the baby is growing, his parents constantly remind him that he's already willed to a boy whom she will marry. Betrothal first excludes other men from having any sexual desire for the woman betrothed. And it imposes on the man the duty to be presenting gifts periodically to the parents of the baby girl. Thirdly, it also allows the man's family to take part in deciding what trade the little girl will learn as she's growing to maturity, or what area of life she may like to have an occupational engagement. And fourthly, it gives the baby girl the right as she's growing to visit the man's family and to take part in activities going on there and express her views on issues being discussed there. In that system of marriage involving betrothal under the customary law, the two people to be married, the young man and the young woman, do not usually have a choice. Their consent is not sought before the marriage. The marriage is between families, not between the two people involved. The two people involved, the young man and the young woman, only engage in procreation, in sexual relation, to produce baby. That is the part that is private to them. Other aspects of their family life is shared by the two families involved. Of course, modernism has got to a point where even in customary marriages, the bride and the groom nowadays have the right of choice, even though parents still play a part in choosing who will marry their children. They now do so in consultation with the children involved. Now let's talk about the validity of customary marriage. Factors or features that make a customary marriage valid. One is consent. I guess I have discussed consent. Yes, because of modernization, the consent of the two people involved must be sought by the families before they go on with the marriage arrangement. But the traditional practice was simply for the father in one family to agree with the members of the family, and they would choose a wife for their son. For the father in the other family to agree with members of his own family, extended family, and then they will accept the husband who has been proposed for their daughter if they want. That's the first condition that makes a customary marriage valid. Then the second is capacity. Capacity means qualification Capacity means having all the ability required for doing something. The first is age, marriage age. In the laws, in the customary marriage laws of the old Eastern Nigeria, the marriage age was put at 16. So no girl below the age of 16 or boy below the age of 16 could marry legally. Then, in Islamic law, in the Sharia law, which is in force among Muslims, the marriage age minimum is 13. So a 13-year-old boy or girl or above can get married. Then, the third, we're now discussing capacity. We talked about age, and then we talked about how it applies, to the old Eastern religion, and then to the Islamic religion. Then, still talking about capacity, there must not be a previous statutory marriage involving any of the two people in the arrangement. Otherwise, the arrangement will be void ab initio, will be void from the beginning. That is, the man or the woman must not have married somebody in the statutory way before coming to do the customary marriage. Of course, we know that in the Nigeria of today, both marriages often take place, both forms of marriages. It usually begins with a customary marriage. We go to the home of the bride and do the customary marriage, which sometimes we call wine carrying, with all the festivities involved. Then after that, we proceed to the church to do what has come to be known as the white wedding. These arrangements, now I'm talking about the third point under capacity. The woman can't marry again. The woman can't marry again after the marriage has been contracted. She can't marry again while her husband is still alive. But the man can marry again. The customary marriage or customary law provides for it. I said before that a man can marry two or more, but the woman can only marry one husband. Then, still talking about capacity, the fourth aspect is consanguinity. It's a very important one. Consanguinity, what does it mean? It means blood relationship. In customary laws, where they relate to marriage, inquiries are made many months prior to the consummation of a marriage arrangement between two people. Inquiries have to be made to make sure that the young man and the young woman who intend to get married are not in any way related by blood. At least in the customary law, a marriage is forbidden between first to fifth cousins. Sometimes there is what is called family marriage, where someone can be married within the family. But it must not be between the first and fifth cousins. I'm sure there are many of us who may not understand this cousin of a thing. Now, a cousin are siblings from brothers and sisters. Siblings from brothers and sisters. Let us take it more simply. The children of biological brothers or biological sisters are cousins. They are called first cousins. That is, mom and mom's sister. The children from mom and her brother. A woman's children and those of her brothers are cousins. They are called first cousins. If the woman or man has a stepsister or a stepbrother, that means he was born or she was born in a polygamous home where their father had a number of wives. Then children from their sons and daughters of the man's stepbrothers or half-brothers and sisters are second cousins to his own children. And if the man's grandfather also was polygamous, the children from his own sons and daughters are third cousins to the man's children or the woman's children. So we continue like that and we have first to fifth cousins. So that is consanguinity, meaning blood relationship. In Nigeria, such people who are so related by blood cannot get married under the custom because it is considered a taboo. Then the fifth point, under capacity. In the Islamic Sharia law, a Muslim woman can't marry a Christian or someone of another religion. But the Muslim man can do so. The Muslim man can marry anybody. But the Muslim woman can only marry a fellow Muslim. Good, let's continue. Now, if a Muslim woman is divorced, she cannot remarry during her Iddah period. Iddah, I-D-D-A. Iddah period means her first 3 months of menstruation. That is, she can't get married again after divorce until she has seen her menstruation. She has seen her menstruation for 3 periods. The reason is that any conception, any pregnancy she has within that period belongs to her late husband. A discussion of the marriage law can't end on a single video like this. So later on our next video possibly, we'll talk about what the law says, really, about a woman carrying a baby and getting married to another man while she's already pregnant. Who owns the baby? The man who is marrying her, or the one who is responsible for the pregnancy. But we're going to talk about that as time goes on. Now, a very important aspect of the marriage laws is inheritance. Now, usually, if a husband dies, in most cases, his first inheritor, the person who inherits his property, first and foremost, before any other person, is the man's wife. But there are provisions of the law concerning this. However, the law does not come to someone's house knocking and asking whether there is an issue. So most often, when there is no issue, the woman inherits her husband's wealth and property. But sometimes there is an issue. That is, for instance, there is a contender to the property. Someone is contesting the right of the woman to inherit the property. That is when the law comes in. The Marriage Act provides, for instance, that the customary law provides that non-natives, people who are not natives of a particular culture, are not allowed to marry in accordance with the customary laws. There was a case in Lagos. A man from Sierra Leone. That case was titled Savage and Mofoy. The case is Savage versus Mofoy. A man from Sierra Leone came to Nigeria, Lagos, studied in Lagos, got a job, started making money. Then he proposed to and married a Yoruba girl, according to the Yoruba customary marriage laws. Years later, the man died and was buried. And when his wife made a move to take over the man's property, a brother of the man from Sierra Leone arrived and began to claim that the property belonging to his brother were his by right of inheritance and not that of the woman. So the matter went to court, and the Lagos court ruled, that is, to go to court, the woman had to apply for a letter of administration. The court issues a letter of administration permitting somebody named in that letter to manage the property of a dead person. So when the woman applied, the brother to her husband challenged it, and the court ruled that the woman had no right of inheritance because there was no marriage in the first place between her and the Sierra Leonean. Meanwhile, the woman had children for the man, children who bore the man's name, both male and female children. So she lost the case, and the man's brother inherited his brother's property. The reason is that the man married the woman in accordance with customary laws, when the law, in accordance with the custom, when the law forbids a non-native, as a foreigner, from marrying in such a way. There was a second case in Ibadan, Nigeria. It was titled Fonseca and Passman. It involved a Portuguese who married a Yoruba, a Portuguese man. They had children, and eventually the Portuguese returned to Portugal. He married the woman in accordance with Yoruba laws. He returned to Portugal and eventually was visiting Nigeria from Portugal, but eventually he fell sick and died. And when his wife applied to the court for a letter of administration to enable her administrate her late husband's property, the court ruled that she had no such right because there was no marriage between her and the man in the first place. So that is what the law is like. Now, the two last of the conditions that make a customary marriage valid are: one, bride price payment. The groom must pay the bride price. It is an amount that is paid to the family of the bride, usually a way of showing appreciation for the time the family spent and the resources the family spent raising the girl who is now to be married. In the old Eastern Nigeria customary law, the bride price was placed at £3. And this is instructive because what it meant was that in the case of the marriage hitting the rock, in the case of a crisis in the marriage and the couples no longer want to get married, the man can only recover £3. Of course, there are other conditions attached to this. Sometimes the money is only recoverable if the woman has not given birth to any children. But if the woman has, meanwhile, given birth to some children, the man inherits the children, and there will be no returning of the bride price that he paid. And the last item that makes last condition that makes a marriage valid in the custom is giving away of the bride. The father of the bride must personally take his daughter in his own hands and hand her over to the groom, thereby finally formalizing the marriage between the two. If you have learned something on our video today, remember to like, share, and subscribe to this channel. Share the video so that it will reach more people, so that the knowledge will not be limited to you. Like this channel so that it will encourage others. So join what we are doing here. If you subscribe to the channel, you'll be receiving our videos firsthand, straight to your inbox. I am still your usual anchor, Obachukwu Honor, the Human Rights Wizard, and at this moment we'll bring this lecture to an end as I invite you to join me on our next video. Remember our slogan here: know your rights, protect your rights, and defend your rights. That way we can have a harmonious society. Stay out of trouble.